as you are probably aware, because there are types of defamation within that are recognized within the judicial legal justice system, and that one is criminal, one is civil. It's important for us to point out that while criminal defamation exists in our books, its history is colonial in nature. Criminal defamation is something that these colonial masters adopted as a way of suppressing dissent amongst the locals at that time, and it has been in our books all this while. And matter of fact is that all over the world, I think it is commonly agreed that criminal defamation is inappropriate, and that anybody who feels aggrieved, anybody who believes that his reputation has been harmed by statements made whether in writing in a permanent form or orally, such a person can approach the court and file a civil suit, and there are adequate remedies that can be made. Courts have over the years made awards of damages against punitive damages against offending persons. Courts have sometimes ordered that apologies should be offered, sometimes in national dailies. Sometimes courts also direct maybe the offending person to take steps to stop the dissemination of the materials that is offensive. And so, yes, I think across the world, everybody agrees that civil suits are adequate to remedy any alleged defamation.
Okay, so while we're talking about that defamation case, as is being alleged now, how would the court actually determine the appropriate level of damage for reputational harm or defamation, as is the case here? How would they know that this is the level that it has caused the person or the complainant harm?
Usually, this would depend on the status of the person who has been allegedly defamed, one, the status of the person, and the nature of the offensive statement that is complained about, and as well as the extent of its dissemination. Usually, these are the things. And of course, if the applicant can also show through tangible evidence that it has a loss of reputation, the reputational loss has actually occasioned actual economic losses. So, for instance, in the case of Dele Farotimi and Afe Babalola, if Afe Babalola can show through tangible evidence that he has lost cases, briefs, or clients as a result of the alleged defamatory statement that was made against him, and that such statement is untrue, then of course the court, it's going to affect the quantum of damages that the courts are going to assess in respect of the matter.
So that's called burden of proof now, isn't it? And regarding this case, who's going to have to carry that?
Is always on he who alleges.
Okay, so it will be on he who alleges that has to prove this. Okay, so are there any... All right then. So are there any procedural steps that Dele Farotimi himself can take to delay or dismiss the lawsuit at any stage, or at this stage since it's still early?
Well, there is only one defense against defamation. I mean, and it is justification. It's simple. So once the truth or justification, all Dele Farotimi needs to do, if he has any evidence of the allegations he has made that would substantiate, that would show that indeed the claims he made are true, or alternatively, that in some other incidences, yes, the learned seal, Afe Babalola, has been found wanting, has been engaging in criminal corruption of the judiciary, then of course, that would be justification, and that would vindicate him in this matter. The The burden of proof, I must tell you, is not such that can be easily satisfied. It would require tangible, provable, tangible evidence to show indeed that yes, Afe Babalola has been engaging in, has engaged himself in corrupting or has exercised corrupting influence on the judiciary as alleged by Dele Farotimi.
Deji Ajare, I want to say thank you very much for giving us your expert opinion on the matter. Thank you.
Thank you so much for having me. Do have a good evening.